Excellent. Okay, we'll get going. So my name is Jessica Palairet, and welcome to our webinar. I'm the Executive Director at Lawyers for Climate Action New Zealand, and this webinar co-hosted with the London School of Economics, Grantham Institute, and I'm thrilled to be joined today by Alina Averchenkova and Catherine Higham, who are both zooming in late in the evening from London. So thank you very much for joining us. And they are the co-authors of two quite significant reports on climate law and litigation that the Grantham Institute published earlier this year. One considers the role of climate legal frameworks on the response to climate change, comparing the New Zealand Climate Change Response Act with equivalent legislation in Ireland and Germany. And the other is a seminal annual report that the Grantham Institute publishes, providing a snapshot and analysis of global trends on climate litigation over the last year. And the reason I think today's topic is so interesting and important is that we know that climate litigation is a rapidly developing area of law all around the world. In the report, the Grantham Institute put the number of live cases at about 2,666 at the end of 2023. But as a small jurisdiction in New Zealand, it's helpful to take a step back and see how New Zealand's climate law and litigation do fit within the wider global picture. So the structure of today's webinar, Alina is going to first present on climate legal frameworks, as you can see on the slide there. Kate will then go on to present about the global trends in litigation and talk about that particular report. And we will reserve around 20-25 minutes at the end for questions. So please put your questions in the Q&A box, which is on your Zoom as you go, and we will try to get to those and answer as many as we possibly can. But without further ado, I'll pass on to Alina to start the substantive part of today's webinar.
Thank you, Jessica, and good morning, everyone. Very happy for this opportunity to share the findings of our research with you at hopefully the time that is more convenient for New Zealand and other countries in the Pacific time zone. So I'll start with the first report that we wanted to share with you today, which has looked at the question of, do climate laws actually make a difference? And this study builds on the research we did in 2018, which was the first one to look at the impact of climate legislation focusing on the UK's Climate Change Act of 2008. And the current study that we're presenting today has looked at the impact of climate laws in Germany, Ireland, and New Zealand. And I want to take this opportunity to particularly thank our interviewees from New Zealand. We have conducted overall for this study 73 expert interviews across the three countries, including many in New Zealand. So if you are one of the people we have spoken to, thank you very much for your contribution. So the study looked at these three countries. Why did we pick this particular three countries and three laws? Well, the common feature that all of the three countries have is that they have had climate legislation for some time, the framework climate laws, but in the past few years, all three countries have amended their regional climate laws to include net zero targets, but also to make some other important amendments to the climate infrastructure, governance infrastructure. So in Germany, we have looked specifically at the Federal Climate Change Act, passed in 2019 and amended in 2021. In Ireland, at the Climate Action and Low Carbon Development Act of 2015, amended in 2021. And in New Zealand, of course, the Climate Change Response Act of 2002, amended by the Zero Carbon Act in 2019. So how did we approach the study? So the study is mainly qualitative. It has looked at the extensive review of literature on the impact of climate laws overall globally, but also in the three case study countries. And then we have conducted interviews with experts, which would be key individuals who are engaged in climate policy debate, either from the public sector, from independent advisory bodies on climate change, civil society, private sector, and also from government and academic institutions. And we have started our interviews usually by posing an open-ended question where experts saw key impacts on of climate change laws, and then we drilled into the specific areas. And this chart here summarizes the areas where across the 3 countries, our interviewees felt the main impacts of climate change laws. And so the overarching, I think, message that we get from our research is that climate laws in the 3 countries we have looked at are delivering on the major expectations that we place for those laws, in particular, and regardless reform to climate governance. So 67% of all our interviewees felt that climate laws in their respective country had positively impacted climate governance, including enabling key climate governance reforms and policies and plans and strengthening associated governance processes. So in particular, what we see is that climate laws are helping address the key challenges in climate governance, such as short-termism, by strengthening long-term approach to climate policy making, and also piecemeal approach to climate policies that we have seen in the past. So the recent amendments with net zero targets and strengthened coordination mechanisms, and in particular requirements to prepare climate change plans, have really strengthened whole of the government approach across all of the 3 countries. So, and this slide shows more specific areas of impact that we have identified. I'll start to give you a little flavor for what we see in terms of climate governance. And one of the most interesting areas that we found was the way in which climate laws address mandates to the public sector to take into consideration provisions of climate laws and also of climate action plans, which are developed as a requirement under those laws, how those different mandates have impact in different ways on coordination and whole of the government approach on climate action. So I'll show you here the comparison. So for the lawyers in the audience, this will be particularly interesting. So if we compare the 3 countries, there is really quite a lot of variation in how public sector duties are addressed in the climate law. So in Germany, bodies discharging public duties shall give due consideration to the purpose of climate targets and set in the climate law and for the implementation. In New Zealand, as many of you would be familiar with, bodies exercising or performing public functions may take the 2050 targets, emission budgets, and emission reduction plan mandated under the law into account if they think fit. Now, if we compare that with Irish law, you can see here that the formulation is much more stronger. The Irish law actually requires public bodies to ensure that decisions are consistent with the climate action plans, long-term climate action strategy, adaptation framework, and other requirements established under the climate law. And what we found through our interviews is that this variation in how the public sector duties are mandated through the law have real bearing on the impact of climate laws. Specifically in Ireland, we have seen examples from the interviews of how this provision has already impacted certain decisions. For example, decisions on infrastructure and Galway bypass been rejected on the grounds of not being consistent with those provisions. And we have also heard from many interviewees that these provisions in Ireland have strengthened coordination and all of the government approach. What this also has bearing on is how local authorities and in general subnational actors take into account climate law and the impact of climate legislation on local action. Again, in Ireland, the provision that you see here on the slide that mandates local authorities explicitly to prepare climate action plans every 5 years has resulted in local authorities starting to work on climate mitigation, which was not previously part of their mandate, and is also promoting collaboration among different local authorities, in particular neighboring ones, making climate action more effective, according to our interviewees. If we compare that with New Zealand, for example, what we have heard from our interviews is that the lack of provisions and specific requirements for subnational climate action for local authorities to take climate action in the climate change law in New Zealand has been seen as a missed opportunity by many of our interviewees. And of course, in New Zealand, that is a very complicated situation regarding planning laws, where previously the planning laws actually prevented local authorities from acting on climate change, and only recently some of those provisions have been removed through also new legislation adopted in New Zealand, planning legislation adopted in New Zealand, specifically from 30th November 2022, local government now must have regard to the National Emission Reduction Plan and National Adaptation Plan under the Resource Management Amendment Act of 2020. I think there was a hope among interviewees that this will have will be a game changer for how local authorities address climate change. But of course, the lack of explicit requirement is still a gap. So let me go back to talk about other types of impacts. So I wanted to talk a little bit about impact on political debate, just to give you a flavor of what we found there. So our research shows that very clearly climate change law has had major impact on the frequency of the political debate focusing on climate issues, but also on the discourse in all of the three countries, shifting the focus from the question of whether we should act on climate to what specific policies and measures should be adopted to implement the climate legislation and to reach the net zero target, but also the specific midterm targets established through the carbon budgets. That confirms that the expectation that climate legislation would help strengthen political consensus on climate change, and partially that is what we find evidence for. If we talk about the backsliding, that is another impact that generally when countries adopt climate laws, this is one of the reasons why politicians go for it, to prevent political backsliding and turning away from climate change targets and objectives. What we found through our research that there is support for expectation. I think there is a general expectation and evidence that climate change laws, in particular when they're passed with general political consensus among the key political parties, as was the case around the Zero Carbon Act in New Zealand, that provides strong protection against backsliding on long-term objectives, in particular net zero targets. However, there is more concern about backsliding on the specific measures to implement climate legislation. And we have seen, analyzing all of the three countries, that requires sustained political commitment, and effectively there is a danger that there is a delay with implementation. So one of our conclusions is that if a climate law by itself does not provide sufficient protection against political backsliding, there needs to be constant political pressure to move the debate and the implementation forward. What was interesting, I think, example in particular in the case of New Zealand, the fact that both Labour and the National Party stood strongly behind the Zero Carbon Act when it was adopted, was seen across all of the interviews we've spoken to as a very strong kind of enabler to prevent the act for being kind of disregarded in the future, in particular its net zero objective. Now, what we have also seen through our research that political leading to the adoption of the law, but also when, for example, climate litigation happens around the climate change law, and that is something that Kate is going to talk about more, also creates very important points for political attention and public attention to the issue of climate change. So media starts writing about it, and that helps raise political awareness about the issue of climate change, not necessarily about the law itself, but the climate change litigation, but also reporting on the implementation of climate change law. For example, annual reports by the Climate Change Commission in New Zealand or by independent advisory bodies in Ireland or in Germany do create information points for media and obviously for Parliament to talk about these issues, and thereby create stronger attention to the issue of climate change. Now, if we talk about citizens and stakeholders and how climate legislation impacts the civil society, what we find here is a mixed evidence. On one hand, many of our interviewers felt it was difficult to assess to what extent climate change law itself helps educate citizens about climate change versus, say, extreme weather events that happen, or Fridays for the Future movement and other action around climate implementation of climate law, but in general climate advocacy. However, what was very clear from all of the 3 countries we have looked at is that climate change law creates a unique opportunity for political advocacy. So leading up to the adoption of the law in the 3 countries, the debate on climate legislation has provided a unifying theme and vehicle for the civil society and for the climate movement to push the climate change debate forward. At the same time, we also understood that once the law is adopted, it becomes more challenging for civil society to campaign around it, because the debate becomes increasingly very technical. You have to know in quite the detail different aspects of the law, and it also becomes more difficult to capture imagination of the general public and together kind of overall support, say, for amending a particular article of the law. What does it tell us? The lesson learned here, an important one, is that when, not for countries who don't have climate change laws yet, or those who will go for a major amendment, it's important to think very carefully the political strategy around the law, because adopting a bad climate law, a weak climate law, could mean that there is a missed opportunity for mobilization. It will be more difficult to improve it later. And it could create a sense of complacency that, well, we already have a climate change law in place, therefore it becomes more difficult to mobilize different parts of society to push for change. The other sets of impacts I'd like to highlight are the impacts on society and emissions themselves. And of course, so when talking about climate laws, this is the ultimate goal. We want to change we want to bend the emission curve. We want to improve resilience of the societies to the impacts of climate change. And what we find here is, I think in all of the 3 countries, it was quite hard from the interviewees to get a judgment on to what extent the law is already impacting emission reductions in countries in question. One of the reasons is that the most recent amendments, which made those laws more ambitious, are still quite new. So some of the real impacts on emissions are still to be observed, I think, in the future. But also it's quite difficult to separate the impact of the law itself, of the legal framework, from the impact of policies which are being adopted under the law. And by the way, here you can see in our report in more detail. I don't have time to go into all of the impacts or we can come to it in the Q&A section. But what we have seen is that definitely climate laws have led to more policies being adopted, and also increase in the cross-sectoral policies that address the whole economy. And they have also, in particular in the case of Ireland and New Zealand, enabled the countries to at least start approaching and kind of discussing in a new way the difficult sectors such as agriculture and forestry, and enable the debate to move forward from the stalemate it was in for several decades before then. But so if we look at the impacts on society and climate, what we do know and what we can see from the data we have analyzed is that in all of the three countries, we see clearly decoupling of emissions from the economic growth. And what we have also seen is clear evidence of shifts in the financial flows, and many interviews directly attributed climate laws as contributing factors to those impacts. We have seen new funds being created. We have also seen fiscal shifts in the fiscal policies and in the fiscal landscape, which can be, some of which can be directly linked to the climate change laws. And finally, very interestingly, we have seen, in particular in the case of Ireland, they have included just transition as an explicit principle into their climate change law. And we have seen evidence that this is enabling Ireland to start kind of make changes in the climate governance and enable more kind of effective approach to just transition. Still early days there. And you have seen on this slide on the right-hand side some quotes from, I won't go through them in the interest of time, but some quotes from some of our interviewees kind of demonstrating some of these impacts. Now, in terms of the core building blocks, the legal building blocks in the framework clause, which were key to those impacts, these were effectively targets, both the long-term net zero target and the mechanism translating that target into the shorter-term ones, namely carbon budgets. Secondly, requirement for the government to create plans to meet those targets, often with specified timeframes. These provisions were key for ensuring whole of the government approach, for improving coordination, particularly horizontally among the sectors, and to enable sectors to give them great accountability for the implementation of the objectives of the climate change law. We've already talked about public sector mandates. And very importantly, and we can talk about it in the Q&A, new institutions such as independent advisory bodies created under the laws and provisions in their mandates in terms of what duties they have, and also how the government is required to respond to the advice they provide, has also major bearing on the impact of climate laws in the three countries we have looked at. And finally, provisions for reporting, assessment, and review. Now, just very briefly, mainly to link to what Kate will be talking about. So we have looked at the core building blocks. These are direct requirements, direct provisions of climate laws that have led to specific impacts that we have identified. But laws also, we found, make impacts indirectly. For example, through increasing institutional capacity to work on climate change, which we have observed in all of the three countries, directly linked to the passage of amendments to the climate laws, to the litigation around the law, but also requirements under subsequent legislation. I've touched upon, for example, the reforms of planning laws that we have seen, in particular in Ireland and to some extent in New Zealand, being inspired by the climate change legislation. An overall signaling effect of climate laws to private sector investments, also to public sector decisions and alignment of policy. And we already touched upon campaigning for the implementation. So I'll conclude now with some recommendations. So I think at the general level, our research clearly shows that countries that don't have climate law have a weak one. we can strongly recommend that there is a case for adopting a new and amending a climate change legislation that sets those key building blocks I've just talked about, and incorporating the most impactful building blocks into campaigns and the structure of the climate change law. It's important that legislation and implementation of that legislation creates or has clear institution for coordinating both horizontally and vertically, but also key provisions for accountability for implementation. And here in particular, we have seen that in New Zealand, the provision of the climate change law that limits the scope of judicial review, we can talk more about it in the Q&A, is a key weakness compared to what we see in other countries, and limits the impact of climate litigation. But I'll let Kate talk more about that. And it's important to actively seek cross-party consensus when amending or developing climate change laws, and to strengthen public awareness and participation. That was a point that was particularly prominent in New Zealand, where current climate change law doesn't really address too much public participation compared to what we see in some other countries. And here are some specific ideas that came up in relation to New Zealand, since a lot of our participants today come from New Zealand. So specifically, as I showed you comparison with Ireland, for example, we felt, and many interviewers spoke about it, strengthening public sector mandates provisions would be beneficial, and also urgent implementation of the Natural and Built Environment Act and the Special Planning Act that would enable local authorities to act on climate change was seen as an important priority. But down the line, it might be important to consider actually explicit requirement for local authorities to prepare climate action plans, like the one that we see in the Irish climate change law. There has been some discussion on the Climate Change Commission. We don't have time to go much into that, but I can talk more about it in the Q&A, suggesting that it's not very helpful to focus on political feasibility as one of the criteria for the Commission's advice. And if we compare it to other countries, that is quite unique in the case of New Zealand. It's important to strengthen the link between the commitments in the Climate Change Zero Carbon Act and the Paris Agreement. That was also seen as one of the issues in the context of New Zealand. I've already mentioned the restriction on the scope of judicial review, and the importance of strengthening participation of citizens and vulnerable communities. And specifically for New Zealand, I think another important kind of suggestion was that it would be useful to focus more on social impacts of climate law and just transition, in particular in forestry and agriculture sectors. So with that, I hand over to Kate to talk about litigation.
Thank you so much, Alina, and thank you all for being here today. It's great to be with you this evening or this morning. As Alina has said, I'm going to move us from talk about legislation and the design of legislation into a conversation about litigation and the law in action. And I will primarily be presenting the findings of our latest report on trends in climate litigation. This is the 6th in an annual series, as Jessica mentioned, but I will also try and relate those trends to the New Zealand context as well towards the end of the presentation. Next slide, please, Alina. So the first thing I should say is, this is a report where we try and show the evolution of the field of climate change legislation as a whole. And in order to do that, we have to draw some boundaries around what we mean when we talk about climate litigation. To do that, we rely on the Sabin Centre and their database of climate cases as the primary source for the report. So we adopt the same definition that they use, and we look at cases before judicial and quasi-judicial bodies that involve material issues of climate change, science, policy, or law. Now, this is, I have to say, quite a narrow approach when it comes to defining whether a case is climate change related. There are, of course, many cases that are about, for example, air quality that could have huge impacts on climate change, but never use the word greenhouse gas emissions or climate change once. But it's quite a broad approach when we're talking about litigation, because we're actually including things like, investigations by oversight bodies or human rights commissions in there, as well as litigation before courts. And what we try and do, taking this sort of global landscape of cases, is to understand these questions that I've put on the slide for you, to really give a flavour of what this whole field is about and who is involved. Next slide, please, Alina. So one of the things that we see in this year's report, and we've seen in previous years' reports, is that the phenomenon of climate change litigation, the idea that courts need to be called on to weigh in on climate change disputes, is spreading around the world. We now have more than 55 countries that have at least one climate change case that has been identified. That's probably an under-reporting, because any effort to track a global phenomenon is of course very challenging. Most of those cases are in the global north, and indeed most of those cases are actually in the United States, which you can see here has more than 1,700 cases, so an order of magnitude bigger than any other country in the world. But we are seeing a growth in litigation in global south countries as well, and there's some really interesting scholarship, particularly challenging the use of the definition that I outlined on the previous slide when we were applying it to the global south. One of the big stories of this year has also been about international climate change litigation, though. You can see from this pie chart that only 5% of all climate cases are before international courts and tribunals, but those international cases potentially have quite significant ramifications. So I wanted to talk about two of them in a bit more detail. Next slide, please, Alina. The first of those is an opinion that was issued earlier this year by the International Tribunal on the Law of the Sea, that was issued in May. This is one of three international courts that have been asked to issue advisory opinions on climate change, the other two being the International Court of Justice, where the opinion was requested by the UN General Assembly, and the Inter-American Court on Human Rights. But the ITLOS advisory opinion may give us a flavour of what we can expect from those other rulings. One of the things that I thought was quite interesting was not only did the tribunal decide that the Convention on the Law of the Sea, which was written many years before climate change became a big issue, before the Paris Agreement applied to climate change, and that greenhouse gases were a marine pollution, but also that countries have legal obligations to prevent and control emissions, and they need to do that by taking necessary measures, and they need to have reference to a 1.5 degree temperature target in deciding what those necessary measures should look like. The court also very interestingly addressed the question of whether or not complying with the Paris Agreement is enough to comply with your obligations under the Law of the Sea, and they said not necessarily. And that's something we might see the ICJ weighing in on further. And finally, there was this quite interesting statement in the judgment that countries may not only have to protect marine ecosystems, but they may actually have to restore them. So that's something that I think we could see litigants in countries around the world trying to think about what that might mean in practice. Next slide, please. The other judgment from an international court, this time a regional court, that I wanted to mention was the case of Klima Signorinen in Switzerland, heard by the European Court of Human Rights in Strasbourg in April. This was the first time that the European Court had pronounced on whether or not the convention rights required states to protect citizens from climate change. They held that it does, at least in these circumstances. There were two other cases that were dismissed alongside this case. and we can get into the reasons for that in the Q&A. But one of the things that I thought was quite interesting in this judgment was that when the court was describing what states do need to do, what are the minimum requirements, minimum obligations that they need to have for their regulatory framework on climate change, they actually had many parallels in that with the core building blocks of the sort of climate framework laws that we identified as having a significant impact in the report that Alina has presented on. And if you're interested in understanding more about the sort of possible connection there, we did put out a commentary shortly after the judgment was published. Next slide, please. So having talked a bit about where climate cases are happening and these international cases, I want to go back to the numbers and think about how climate change cases might be evolving over time. And one of the things that's been remarkable is that we've seen really considerable growth in the number of climate change cases being filed every year, or at least the ones we are identifying, with more than 70% of identified cases having been filed since 2015, the year of the Paris Agreement. The current data suggests that increase may be actually turning into a slowdown in the rate of new cases filed, although we're still seeing well over 200 cases filed each year. I think this is actually partly to do with delays in data collection. Of course, collecting this amount of data is a really mammoth task. But I do think we could be seeing a bit of a plateau in the number of cases that are being filed, possibly because we're seeing people waiting and seeing while some of the more innovative cases are making their way through the courts, particularly in the world of corporate climate litigation. We could also be seeing differences in the political landscapes in different countries having an impact on this, and potentially also the kind of professionalization of the climate litigation community having an impact, with more resources being put into a smaller number of targeted cases. Next slide, please. I wanted to contrast, though, the graph you saw in the previous slide with this one, which is our attempt to identify all of the strategic cases against companies. And where we see that we may be seeing a bit of a plateau or possibly a decrease in the number of new cases filed overall, that is definitely not true here in the realm of corporate climate litigation, where we are seeing actually quite sustained growth. We're also seeing corporate climate cases being lodged against a wider range of companies than we have seen in the past. And that's partly because of the rise of climate washing litigation, cases where litigants are challenging statements a company has made about their products and services being climate neutral, or challenging a company for having a net zero target and no adequate plan to meet that. But it's not just those cases, and I think we're not going to see corporate climate litigation slowing at any time soon. Next slide, please, Alina. I'm going to talk a little bit more about what we mean by strategic climate cases and the kind of things that we're seeing in those cases. But first, I do want to make the point that litigation is a double-edged sword, and not every climate case is aligned with climate goals. From the 2023 cases, although 75% could be described as pushing for more climate action, more accountability for governments and companies, at least 20% were actually pushing back against climate actions and measures. We see two distinct groups of cases within that. First, we see what can be understood as sort of anti-climate litigation, so cases challenging, for example, sustainable finance initiatives and efforts to incorporate environmental and social governance factors in investment decisions. And we also see strategic litigation against public participation, with big companies filing lawsuits against civil society groups, many of them the same civil society groups that are filing lawsuits against the big companies in court. So there's this kind of back and forth. But we also see two more complex groups of cases that we talk about in the report. Firstly, what we call just transition cases, where litigants are not necessarily saying they don't want climate action to occur. And in fact, in some of these just transition cases, they're actually saying climate action isn't ambitious enough. But they are challenging the way in which climate measures have been designed because they haven't taken social impacts into account. This year, we also identified a new group of cases that we call green versus green cases, where you're seeing arguments about the balancing of the need for climate action, renewable energy projects, and so on, with the need to protect biodiversity and ecosystems. There are some reasons to believe that some of these cases may not be being brought in good faith, that actually some of the actors involved in these cases are being funded and supported by actors that we know have been involved in climate denial and obstruction for a long time. But then there are other cases where this is a really genuine question about how do we balance competing priorities. And an interesting example of that is the case of M.K. Ranjit and India, which was heard earlier this year, in which the Indian Supreme Court enumerated a constitutional right to be free from the adverse effects of climate change, and then tried to balance that against the need to also protect biodiversity. So really interesting case there. Next slide, please, Alina. But getting into what is actually going on in the bigger group of climate-aligned cases, I wanted to talk a little bit about the sort of typology of cases we create in the report, where we look at the different types of strategies that litigants are using. The biggest two categories of cases are government framework cases and integrating climate considerations cases. The first of those is cases like the Klimasyniorinnan case, which are challenging a government's whole of government policy response to climate change, often challenging the ambition of targets or whether governments are doing enough to meet their climate targets. Integrating climate considerations, though, is also a huge group of cases, perhaps the biggest, and we actually don't know how many cases there are in the US overall. And this is where we see particular administrative challenges to government decisions about projects or policies. And this is still the bread and butter of many climate cases. An interesting decision that we highlight in the report is the case of Finch and Surrey County Council. The Supreme Court here in the UK has just ruled on that case, and it basically concerned whether or not existing environmental impact legislation could be understood to apply to not only climate change impacts, but also to Scope 3 emissions and the environmental impacts associated with Scope 3 emissions from a project. And the Supreme Court has held that Scope 3 emissions are something that needs to be taken into account in an environmental impact assessment. We see something similar from a case in Norway at the end of last year, and I think that's an issue that's going to be coming up in many different cases going forwards. The next two sort of categories of cases on the screen, polluter pays and corporate framework cases, are really the primary cases against companies that are concerned with their causal contribution to climate change, and not just this question of climate washing. Polluter pays cases are those where the claimants are trying to establish that a company has contributed to greenhouse gas emissions and should be held responsible for paying for either the prospective costs of adaptation or for damages actually sustained as a result of climate change. There aren't very many of these cases around the world, only about 30, most of them filed by cities and states in the US, but a small handful in Europe as well. And then there's the corporate framework cases, which are prospective cases arguing that companies have a duty to mitigate their emissions and align with the Paris Agreement. And of course, you will be familiar with the Smith and Fonterra case, which is an interesting one of these cases that has survived at least the initial challenges and is now likely to go to trial. The other leading case in this area is Milieu de Foncy and Shell, which was heard in the Netherlands and which is currently under appeal after the Hague District Court did order Shell to increase its emissions reduction ambition. And then we have these other groups of cases. I've already talked about climate washing. We also have turning off the taps cases. Those are cases basically trying to follow the money, targeted at financial institutions, whether public or private, in the hopes that that's going to sort of make it harder for big emitting projects and companies to continue with business as usual. We have failure to adapt cases, an interesting group that is increasingly being filed against companies as well as governments, looking at whether or not enough measures were taken given that physical risks were known. And then we also have a new group of cases we introduced this year, transition risk cases. And these are really about whether or not companies' directors and officers are understanding the climate transition well and making good decisions for the company. They share a lot in common with corporate framework cases, but the key difference is that while the corporate framework cases are concerned with the need to reduce emissions because of the impact that they're going to have on communities and stakeholders, transition risk cases are concerned with the impact it's going to have on the company's bottom line. So having introduced all of those, I wanted to then give a picture of what's happening in New Zealand. Next slide, please, Alina. And you can see that we don't have every type of climate case being documented in the New Zealand context. For those of you on the call who are involved in climate litigation and familiar with it, it will be no surprise to hear that the majority of cases that we've identified are against governments. There are some notable government framework challenges, including the Thompson case that was heard before the Zero Carbon Amendment Act came in and before the Ardern government, and which had some pretty positive statements, despite essentially being decided when it was already moot, and the Smith and Attorney General case that was dismissed more recently. And then you have the integrating climate considerations cases, which are really the kind of where the majority of the action is in the New Zealand context. I think it's interesting that the Zero Carbon Amendment Act and its changes to the Climate Change Response Act haven't been the hook for as many of these cases as we might have anticipated. There is, of course, an interesting case that was referred to by many of our interviewees for the report that Alina was referring to, where Lawyers for Climate Action challenged the failure to follow the advice of the Climate Change Committee in setting carbon budgets, in setting the cap for the emissions trading system. And many people pointed to that as a sort of impactful and interesting case, and it's certainly one that wouldn't have been possible without the Zero Carbon Amendment Act. But as Alina has alluded to, the wording of the public sector mandate provision in the Act hasn't given, I think, as much impetus to climate litigation as we've seen in, say, Ireland and elsewhere. So interesting how that sort of potential weakness in the design of the Act is playing out in court cases. Although I understand that there was a recent decision in Students for Climate Solutions case concerning new oil and gas licensing, where there was a dissenting judgment that might be grounds for thinking there's more mileage that can be got out of Section 5ZN than has happened so far. We also see, of course, the Smith and Fonterra case in that corporates category, and then several climate washing cases mirroring the trend that we see around the world. But some of the things that we haven't seen a lot of are adaptation-focused litigation. We haven't seen many of those transition risk cases, any of those polluter pays cases, although, of course, there it might make sense to wait until Smith and Fonterra is finally decided before thinking about what those whether there's scope for those kinds of cases. And we don't see many of these cases against public and private financial institutions. I did think something that is interesting in the New Zealand context that we don't see in some other places is the focus on sort of immigration cases that we have seen. Of course, we also saw the UN Human Rights Committee asked to weigh in on one of those cases a few years ago. And if we look at other places in the world, this is an issue that is coming up in other contexts. And there's an interesting judgment from the Colombian Constitutional Court that we talk about in the report, which is basically requiring the legislature to come up with legislation to protect people who are displaced as a result of climate change because existing protections for refugees don't apply to them. So quite an interesting case there. Next slide, please. And this is my last one, Alina. So the final thing I wanted to talk about is what is the outcome and the impact of climate change litigation. We've already heard from Alina that climate change laws have had some significant positive impacts. And I think we can broadly say the same thing for climate change litigation, but it's very important to understand that that varies from case to case. If we look at the direct judicial outcomes in climate change cases, we can see this by comparing climate washing cases and government framework cases. In climate washing cases, we have more than 70% of the judgments being positive for climate action. Basically, the courts agreeing with arguments that misinformation is occurring. But it's not clear what impact those are having in the long run, because typically the companies just stop saying whatever they were saying, and it's not clear that that's leading to a reduction in emissions. By contrast, only a third of government framework cases are successful, but even the unsuccessful ones have had significant impacts on the narratives around climate change in different countries, and the successful ones have had really significant impacts. So I think it's important when we're thinking about this to really bear in mind that we're not talking about something that is very uniform. We also know, of course, that climate cases have significant impacts beyond the courtroom. They can spur legislative reforms, they can open avenues for new cases, change narratives, and we're also starting to see them as a vector of financial risk. I'll stop there so we have time for Q&A, but thank you very much.
Thank you very much to both of you. They were really interesting presentations. Encouraging everybody to put your questions in the Q&A box. We have one question around criminal cases, and the question is, do you consider criminal cases where the defence of necessity is being argued to be a class of climate cases? There was one of those recently in New Zealand.
Thanks. That's a great question, Ben. And the answer is yes, we do, and they are included in the Sabin Centre's database. We've written about them more extensively in previous years' reports than in this year's report, because they throw up some really interesting questions about whether or not they can be understood as strategic cases or not, right? Like, it's not the protesters that decide to bring the case, it's the prosecutors, but the protesters did know there was the possibility of a case arising from their actions, and they may have had an intention to use the courts as a forum for making their arguments potentially more publicly. I've written a recently published chapter in a book on climate litigation about this, if you're interested in seeing some of the comparisons. It's the book published by Edward Elgar and edited by Francesco Sindico. But yeah, it's a really interesting area.
Thank you, Kate. I might ask a question about the growth in corporate climate litigation that you talked about, and I'm interested in what you predict in this regard in terms of potential trends. And I'm thinking here around new regulation, particularly in the EU, but we're also seeing the coming into effective regulation around corporate climate disclosures, for instance, in New Zealand, and the effect that those regulatory changes might have on the climate litigation landscape.
Yeah, I think this is a really interesting question. And, you know, in the past, we have seen climate change litigation acting as a bit of a gap filler when there isn't a lot of regulation in the climate change context. And I think as we see the regulatory landscape changing, what we'll see is a change in the way that litigation is being used. So rather than necessarily trying to fill the gaps, we'll be seeing cases that are about implementation, that are about trying to question the way in which those regulations are being interpreted, and so on and so forth. But I don't think it's necessarily going to lead to a decline in the number of corporate cases, just a change in the type.
Mm-hmm. Thank you. And we have a question about the adaptation cases, and I think this relates to a question more about the scope and nature of the report, around the timeline for when climate adaptation cases and when cases were considered. Is this person saying that there maybe were some cases, or there are some cases coming this year on climate adaptation?
Yeah, the graphic that I showed was based on an assessment of the cases in the Sabin Centre database from 2015 to this year. So if there are cases that fall within that time frame, it may be that we haven't captured them, and I'd love to follow up and learn more about them, because it is such an important and significant issue, and one that I think we're bound to see more litigation on in the future. But yeah, that's the time frame. And so as I said, we know that what we've captured is is not the entire picture, as with any kind of global effort to understand data. But please do email me about those cases.
We have one other question about the impact or the extent to which the report considers the impact of threats or concerns about possible threats of litigation on political decisions versus whether the report focuses on actual cases. But I think potentially it might be interesting if you talk about the role of climate litigation in changing political or influencing political decisions more broadly and what you see internationally in that regard.
Yeah, that's a really interesting question. We did write about sort of litigation that never actually makes it to court having an impact in, I think it was the 2023 report, but it could have been the 2022 report. And this is, of course, something that's really hard to study, because when a case is threatened but not actually brought, we may not even know that there is that threat in place. So in the few examples that we have seen, we do know that the threat of litigation has led to changes in investment decisions by companies, for example, and we suspect that it has also led to changes in the way that government actors respond. And certainly our research on the impact of climate laws suggested that there was a real awareness of litigation among people in the public sector, and that was one of the reasons that litigation was kind of driving action. I don't know, Alina, if you want to comment more on that part, but we don't have as much evidence for it as we'd like.
I think one example that we could refer to is the UK's decision to amend, to amend the target under the Climate Change Act of 2008 to net zero. And from informal conversations with some experts involved in that process, we have heard repeatedly that the threat of climate litigation was a factor, one of the factors, an important one in the government's decision on net zero target. So I think it certainly is part of the political decision-making process. But what one should also be aware of, I think that in particular when I talked on climate change legislation in some of the countries that don't have a comprehensive climate law, sometimes that does come as a concern as well from the government. You know, would we then be exposed to the risk of litigation, and is it then a deterrent for some countries to actually go towards a comprehensive climate law? So I think one needs to approach it with some caution as well when discussing it, I think, with governments that don't have a climate law yet.
I think we might have time for one more quick question, particularly two if the answer is very quick. But there's a good question in here about an important category of climate cases that wasn't highlighted in the slides, and that relates to Indigenous climate law cases and issues and perspectives. And there are a couple of examples of that in New Zealand in particular. So the question is whether the Grantham Institute and Saving Centre is does track Indigenous climate litigation specifically, and your reflections more generally on that.
Yeah, I think this is a really important category of cases. And again, it's not something that we covered in great detail in this year's report, but we have talked about it in previous years. And it's also something that Maria Antonia Tigre from the Sabin Centre has been doing quite a lot of work on. So absolutely, you can identify those cases in the database. And there are Maria Antonia and other scholars who are doing quite a lot of thinking and writing about some of these arguments. I think, of course, one of the reasons that they're harder to write about in a report on global litigation is that they are so specific to the context, right? What is happening in New Zealand is very connected to the way in which Indigenous Crown relations are structured, and that won't be the same in Canada or in many countries in Central America. So there are sort of a range of different things that need to be considered, but there is some great scholarship on that.
Mm-hmm. Wonderful. And I realise we've reached time. I would just say one point on Indigenous climate litigation is there is a really interesting proceeding going through the Waitangi Tribunal, which I would encourage you to keep a track of, as it's quite a significant case in New Zealand on the Crown's obligations towards our Indigenous peoples, Māori. But all that being said, thank you so much for your time.